my name's Jude Eyre, and I'm an Associate Director at the Nuffield Family Justice Observatory. And today I'm going to be talking to you about how we enhance the voice of the child in private law proceedings, and particularly within the Pathfinder areas of Wales. For those of you who haven't come across the Nuffield Family Justice Observatory before, we are part of the Nuffield Foundation, which is an independent charitable foundation that largely funds research into social wellbeing. And they set up the observatory about 5 years ago now to improve the use of research and data in the family justice system with the ultimate goal of improving the lives of the families that the system is there to serve. So we create research, we commission research, we undertake research ourselves, we share that with others, and we have conversations with people across the family justice system: children, adult family members, lawyers, judges, magistrates, legal advisors, social workers, those working in third sector organisations, to really understand their experiences and what they think is going on and is sitting behind the research. And then finally, we try and support innovation so that we can bring to life the research findings and make things better on the ground. So that's why I'm so pleased to be speaking to you today about how we can make things better and bring this to life on the ground in the Welsh Pathfinder areas. Today's session is focused on an area that we've done quite a lot of work on as an observatory, and that is children's participation and their voice within private law proceedings. So today I'm going to summarise the key research findings in relation to what we know about the current levels of our participation and why participation matters from children's perspectives. And then also I'm going to explore what practical steps we can be taking in the courts every day to improve children's experiences in this area. When the Pathfinder model was being developed, one of its key objectives was to improve how we hear the voices of children. And really, that's what I'm aiming to do today, to give you some ideas and start some discussions about how, as magistrates and legal advisors, you can take the messages from these research findings and put them into practice every time you're dealing with a family in front of you in court. So starting off then, I'm going to talk about the current levels of participation. And when I say current levels, I mean the levels of participation under the child arrangement programme, so the standard model for doing private law proceedings. And these graphs come from a report by Dr. Claire Hargreaves, Dr. Linda Custworth and their team at the University of Lancaster, and it was published in February of 2024. They looked at data from Cafcass and Cafcass Cymru, and they looked for what they call markers of participation. So that's really any indication in the data that children are likely to have had the opportunity to have been met with and to be spoken to. And the markers they were looking at were reports conducted by Cafcass or Cafcass Cymru, or where they were involved, the local authority. So that's reports under Section 7 and Section 37 of the Children Act, or where children are joined as parties and have a guardian appointed for them under Rule 16.4 of the Family Procedure Rules. So what you can see from these graphs is that around half of children involved in the cases that were looked at had a marker of participation showing in the data for their case. So that's just over half in England, just under half in Wales. But on average, around half of children didn't have any indication that they'd had the opportunity to participate and to feed in their views in any way. And it's also worth noting that while we do see some variation in age, there isn't as much as perhaps you might expect. So the Children Act talks about considering the ascertainable wishes and feelings of the child concerned in light of their age and understanding. And Article 12 of the United Nations Conventions on the Rights of the Child states that the child capable of forming his or her own views has a right to express those views freely in matters affecting them, and they should be given due weight in accordance with the age and maturity of that child. And that's why I say it's perhaps surprising that we don't see a more marked difference for older children in this cohort. So for still more than 2/5 of 12, 13, 14-year-olds, we're still not seeing any obvious sign of participation within the data. So is that an issue? Is it something that we should be concerned about? Well, discussion on this point far predates the establishment of the Nuffield Family Justice Observatory. For many, many years, people across the system have been talking about this issue and have suggested that fundamentally this is a problem, that we don't hear children well enough, that we hear them too infrequently, and that when we do hear them or when they do participate, that happens too late on in proceedings. So here are just a few examples of that, people making that very point. Olivia, a young person who's a member of the Family Justice Young People's Board and has lived experience as somebody going through the family justice system, talks here about how it's simply not good enough that children don't have a greater voice. The Harm Panel report in 2020 flagged concerns about situations, particularly situations where children has experienced domestic abuse, and talked about children's voices being unheard or muted in these circumstances. And then finally, Sir James Mumby, the former president of the Family Division, describing children as by and large invisible in the family court. And from a research perspective, the research from England and Wales and the international context as well really highlights why this is problematic, because the research talks to the importance of children feeling heard and understood when the court is making decisions about their lives, children having told us this in multiple studies over many years, and also the difficulties they can experience when this doesn't happen. So to begin with, I'm going to unpick that evidence base a bit more to understand the key messages from children, to help us understand what matters and what needs to change from their perspective. And then I'm going to move on to talking about what those changes might look like in practice. And in doing so, I'm going to speak to 6 messages on this slide, and I'm going to speak to them in turn. The messages themselves come from a research summary by my colleague Alice Rowe, which was published in 2021. And it looked at the national and international evidence on children's experiences of separation and private law proceedings over around a 20-year period. The first message she highlights is that parental separation can be distressing, traumatic, and confusing. Well, for anyone who has experienced separation as a child or as an adult or worked in the system that supports those who have, I think that finding might be a bit obvious. Feel like it doesn't really need saying, perhaps. But I do think it's important for us to reflect on what children have already experienced before they come into the family court system. They talk about distress, difficulty, and loss. They describe a real sense of disruption to their everyday lives as a result of the change of their family circumstances. And there's also a really strong theme of confusion, which we're going to hear some children talk to now.
I did get told one day, "Oh, we are getting a divorce," but it was so casual that it was almost like nothing. And when my mum moved out, she didn't actually tell me, and she took my brother with her. I remember my sister knew, my dad knew, but no one had actually told me.
Then she found more messages and just was throwing his suitcase and things down the stairs, and that's how my little sister found out.
I didn't think they told me, but it was very obvious. One day we woke up, whatever. He was acting strange, but me and my brother didn't think of it. But I was at school, so I don't know what happened. And then he obviously didn't come. Well, no, he tried to come, I think in the evening, but our mum wouldn't let him in. The police were here.
Those are direct quotes from children in Wales and the southwest of England, voiced by actors to protect their confidentiality. And they come from a study by Dr. John Simons and his team at the University of Bristol that was published in 2022. Those children are talking about situations way before the court ever became involved. For many of them, situations where the court never did become involved. But I think they are helpful because that sense of confusion, of trying to piece together what is going on as their worlds collapse around them, is a theme that's very strong and persists throughout the evidence base, both in terms of children's experiences of separation and their experiences of court proceedings. Children repeatedly talk about feeling like they were being kept in the dark during their parents' separation, both by their parents and by any professionals they were involved with. Children talk about adults trying to hide or keep information for them in order to protect them from adult issues. And whilst the reasons for that might be well-meaning, children in the research reflect that they often actually knew more than the adults around them realised. But again, they didn't have the full picture or enough of the picture to make sense of what was going on. They were left trying to fill the gaps in their understanding. And in doing this, without access to proper information, children came up with their own, often very worrying ideas about what was going on. In terms of proceedings, children often associated court, law, and lawyers with criminal cases and punishment, and articulated being scared that their parents might be sent to prison. The research is clear that the lack of explanation and information provided to children actually caused significant distress. So in some ways, we're adding distress on top of what the children were already experiencing by virtue of the separation and any related conflict. And that comes from our failure to provide sufficient information and explanation. Hence message 2, that good communication and access to information are important. In essence, because this is the antidote to children having to try and fill in the gaps themselves. That rather than leaving children with a range of worrying, unanswered questions and the possibility that they come up with their own incorrect and often self-blaming answers, if we communicate well in a way that is tailored to their age and understanding, we can minimise that confusion and also the distress that can flow from it. But I think communication is a key word here, because it has to go beyond us merely giving children information into a two-way process. And that links on to messages 3 and 4, the power and importance of children feeling heard, and how this can genuinely make children feel better in the context of really difficult situations that they're finding themselves in. The research highlights that, perhaps unsurprisingly, different children would like different things. Some children in the research expressed that they didn't really want to be involved, but I do think it's important to note that that was a small minority of the children within the studies. For others, some wanted to meet the judge. For some children, meeting with a professional and having them feedback was enough, really met their need for how they wanted to participate. But this evidence really points to the need for options so that different children with different needs can participate in different ways. Done right, the research talks about involvement and consultation in decision-making as a possible pathway to improved experience, with potential knock-on impacts for how positive children feel about the decisions being made, even in situations where those decisions are different to what children have said they would have chosen. And to explore that a bit more, we're going to hear from Jamie Craig, who's a consultant psychologist and former psychologist for the Family Justice Council. And he's reflecting on this research summary and how these messages can play out in practice from his perspective.
I think we are often very careful to think about how important it is to shield children from harmful and distressing experiences. And I think it's a difficult balance often, and one where parents and professionals probably struggle to strike that balance. And I think the message that desire to protect might actually end up not feeling very protective at all, and that children are actively involved in their parent separation, whether we choose to believe it or not, is a really useful point for professionals to pay attention to. I think particularly for older children, there's often a kind of a concern that them being asked about the conflict or asked about the separation might lead them to feel pulled into protecting one parent or taking sides. And I think those are really important things to pay attention to. However, there's a danger of walking that line of missing the lived experience of that, which is that I have been around the separation. It's affecting my life. It's my day-to-day life that's going to change, and to not ask me about it, or to not ask me enough about it, and give me enough information, can make me feel, I guess, passive in terms of the decisions, but active in terms of the lived experience of the conflicts. And so it can be the worst of both worlds. And I think that desire to protect is a really good desire. We're wanting parents to be protective. We're wanting them to not draw them into or expose them to conflict. However, that can, I think, and the document helpfully points that out, that can, I think, sometimes lead us to not allowing young people to tell us about their experiences and their wishes when we are erring too much on the side of caution there.
As a final piece of evidence on this topic, I wanted to share with you something fairly hot off the press, extracts from a study by Rebecca Jones published at the end of 2023, where she had spoken to children in the North Wales Pathfinder about their experiences of being spoken to as part of the Pathfinder process. These were children who'd been met with and spoken to by family court advisors prior to the first hearing in their case, as is the Pathfinder model. And their accounts really echo the messages from the wider research about the really positive benefits of being able to be involved, to be heard, of feeling like a weight had been lifted off them, in the words of Theo, of feeling relief because they'd been listened to, in the words of Eloise. And to be clear, what these children are saying is nothing particularly new. It's very much in keeping with the other studies from this country and internationally. But I think it's a really timely reminder that even a relatively small interaction can make a big difference in terms of how children experience proceedings and their life in general. So finally then, the last two messages. This is about how we get it right for children, the vital importance of children feeling that they have been supported, whether that's through specialist support services, such as domestic abuse partner agencies in the Pathfinder areas, for example, or simply through all the professionals who are working with them, being empathetic, properly listening, and appreciating the seriousness of the situations that children find themselves in. Children in the research make clear that they don't want to have the weight of feeling that they are the ultimate decision maker. And of course, they are not. We as professionals have the responsibility of enabling them to participate in the ways that work for them, to feel heard and supported without carrying that fear and that weight. And that is entirely possible. I think I'm right in saying that none of the children spoken to in the North Wales study described any feeling of responsibility in terms of being the ultimate decision maker. I think it's also important to accept that children's experiences, thoughts, and feelings can be complex. And that's the final message. It comes out particularly strongly in situations where children have experienced domestic abuse. It's not a reason not to talk to children, but it is a context that we need to understand. And it means it's always important for us to be thinking about the individual child when we're thinking about the processes and timescales in our cases. This message, for me, really challenges us to think about how we make a system that fits the needs of the child, rather than making the child simply fit a system as we have built it. So finally, on the evidence, I'm going to reflect a bit on what it tells us participation is for. And as you'll see on the slide, I've started off with the Children Act, Section 1, the legal function of participation. Participation speaking to a child can provide us with evidence of their wishes and feelings to inform decision-making under the welfare checklist. And I think historically, as a system, sometimes we've behaved as if this evidence-generating function is the only reason to talk to children and for them to participate in proceedings. But actually, what you've heard is that it's more complicated than that. Even from a legal standpoint, we have to think about the United Nations Convention on the Rights of the Child, and this being a mechanism by which we uphold children's rights under international law to be involved in the decision-making processes about their lives. And when you start to think about what that wider evidence talks to and what children have told us, participation means for them many more things than to simply meeting the legal requirements. So on the bottom left, it gives children the opportunity to ask questions, which helps them fill those information gaps that I was speaking to earlier. In the middle at the bottom, it talks about children understanding what the court is and who is making decisions. Again, an opportunity to address any potential confusion that might be compounding children's difficulties and in their experiences. And at the bottom right, it helps children understand how their views will be used in the decision-making process, enabling them to have a confident understanding that they will be heard. And so finally, ultimately, at the top, you will see what this might add up to, providing us with the benefits identified where participation provides a means by which we actually improve children's experiences of proceedings, where they feel listened to. And this is such a strong and important theme coming out of the research. Finally, I'm going to add in two which aren't covered in that wider evidence base in any detail, but which I wanted to share with you as reflections emerging from practitioners in Dorset and North Wales as the original Pathfinder areas. When I've spoken to practitioners in those areas, be they judges, lawyers, magistrates, legal advisors, family court advisors, social workers, there are two other really strong themes that have come out from my conversations. The first, which is in the top left, is that giving the child an opportunity to participate helps keep the child really firmly at the centre of decision making. Thinking back to Sir James Mumby's reflections that children can be by and large invisible in the family court, participation in Pathfinder areas has been reflected on as a means by which this is much less the case, where we bring the child much more firmly into view and keep them there in all the decisions we are making. The second area of reflection is that just as we bring the child more into the visibility of the court and help the court to think about the child's views, wishes, feelings, and experiences, we also make this much easier for parents. Practitioners reflect that this greater focus on the court listening to children helps parents do the same, and in turn supports them to reach early agreement and resolution of issues. So in short, participation enables a lot of different things. It's meeting a number of needs and it's providing a variety of opportunities. So then, what does it look like on the ground when we try to build a system that is really grounded in the evidence of enhancing the voice of the child and enabling meaningful participation? I think it can be helpful to focus on three main areas of activity. The first is good quality and accessible information for children, particularly at the start of proceedings, but also during proceedings and at the end. The second is options for children and young people about how they want to get involved. This going back to that key message that different children will want different things, and as a system, we need to be able to accommodate that. And then finally, feedback on what has been decided and why. It's really sad to hear children's accounts of situations where they have been involved in proceedings, fed into proceedings, or where they knew proceedings were ongoing, but nobody took the time at the end of those proceedings to explain to them what had been decided and why. So hence the third recommendation in terms of building a system that meets children's needs around participation, to really think about closing that feedback loop at the end. So starting off, we're thinking about that clear information at the start of proceedings. And that could take the form of letters from Cafcass or Cafcass Cymru in Wales, leaflets from the court, both for children and also for their parents. But in those that are created for parents, thinking about how we explain why the court sees participation as important and how that might be enabled for their child. And then also perhaps other means like videos explaining key concepts around who people are within the court system, what they do, how they make decisions, and what the court looks like. So in terms of really practical examples, here on the slide, you can see a picture of the first page of an introductory letter from Cafcass Cymru to children, which is sent out to children prior to them meeting with their family court advisor. It explains things like what the family court is, who Cafcass Cymru are. It talks about the options by which children can have about their participation. It describes the kinds of things that family court advisors will talk to children about. And it introduces the family court advisor, so it includes some personalised information about the person they'll be meeting, like hobbies or pets, for example. So the second thing that the system would need to focus on is that options for children in terms of how they can be involved. And you'll see on the slide a very wide range of options, not all of which will be appropriate for all children in all cases. But I think it's just important for us to be pushing ourselves to think more broadly, so that we're not simply seeing a child meeting with a family court advisor or a local authority social worker as the only means by which they might want to participate. And even within that, we need to acknowledge that that meeting itself might look very different, that children might have views and preferences about where they meet their family court advisor or social worker, whether that happens online or in person, if there's a sibling group, whether that happens with all the siblings together or whether they want to meet individually. But also, as I said, to think about the options for participation that are beyond that type of engagement with family court advisors or with social workers. It isn't the only mechanism by which children can participate. They can write to judges and magistrates. They can meet with judges and magistrates. Those kinds of opportunities can really help them feel that they are heard, understand the person who is making the decisions for them. So a practical example in this situation is children meeting with judges and magistrates. And on the slide, you'll see a image from the top tips provided by the Family Justice Young People's Board for judges and magistrates on meeting with children. And also some learning from North Wales, where practitioners in North Wales feel there's been a significant increase in the number of children and young people meeting with judges and with magistrates. And on reflecting on what's made that work, practitioners have described the importance of really being upfront with children about this, the fact that this is an option from the beginning. So family court advisors and local authority social workers having that conversation. Everyone being clear about what that meeting is and isn't for. This isn't an evidence gathering exercise, but this is for children and young people to really understand a bit more about the people who will be making really quite fundamental decisions about their lives. So family court advisors discussing with children as part of their child impact report in the Pathfinder areas, whether they would like to meet the judge and magistrates, and if so, what that might look like. So this might be, if it's a case that's likely to be heard by magistrates, for example, talking about whether meeting with a full bench is something that children feel that they would benefit from, or whether they might find that number of people overwhelming and whether they'd rather meet with the chair of the bench or legal advisor. So the idea is that that information is then put into the child impact report and that is shared with the court, and the court can then make directions to facilitate what would need to happen for the child's wishes to be met. It's important that as the court we are flexible enough to respond to what children have told us and to meet their needs. So once again, thinking about how we fit around what the child needs rather than how the child fits in with our systems. And then finally, good communication is absolutely crucial between family court advisors and the court in terms of making sure those practical arrangements run smoothly on the day. It's really positive to hear from North Wales that they do feel that they have made significant progress in this area and that it's been really beneficial for children where more meetings have been taking place. So the third area of focus is around feeding back to children on what's been decided and why. So you can see here, again, there are different ways in which this can happen. It's something that comes out as really important from the evidence base, the closing that loop for children, especially as will be more common in Pathfinder, where they have fed in to the process. And there you can understand why it's so important for them to understand how their wishes and feelings influence decisions, what was decided and why. And the template orders in Pathfinder areas now have a prompt to record in final orders who it is that is going to tell the child. And there's also provision for discussion around this in the child impact report, so that family court advisors or social workers can be discussing with children their preferences in this regard, so that the court can take that into account. So in terms of practical examples, there are different ways of doing this depending on the circumstances of the case. So the first example is situations where parents or carers are being asked to feed back to children. And at present, this is by far the most common situation. But previously, as a system, we haven't really given much thought to how we might support parents and carers in this task. So on the slide, you'll see a document that is now live on the Cafcass Cymru website, and a version of which is currently being prepared in England to be used in Birmingham and Dorset. It's written for parents and carers in those situations where the court is asking that they be the ones to provide feedback. And it was prepared with input from children and young people, from adult family members with lived experience of the family justice system, and with the input of a broad range of professionals. It really recognises that parents and carers might find this quite difficult. They're dealing with their own emotions about decisions that have been made. And also, they might simply be really worried about getting it wrong. So it gives us things to think about. It gives examples of language to use. It includes links to places where families might want to go for support. And I'd really recommend actually to all practitioners working in the system reading this document, because I actually think the thought that has gone into helping parents to communicate with children about these issues can be really helpful to all of us in thinking about how we communicate about these issues in ways that are clear and accessible and really child-focused. Another example of how children can receive feedback is when judges or magistrates write to children. So this could be the basis upon that the parents then uses to have the conversation with their child, or it could be in situations where the court feels that it'd be more appropriate because of the dynamics of the case for Cafcass or Cafcass Cymru to be feeding back to the child. It might be that the court chooses to write full judgments or reasons in child accessible language, or the court might write a judgment or reasons in the normal format and then have a letter as part of that, either, as is the case on the slide, the letter from Judge John, which was an annex to an order, or perhaps even, as is the case for some other judgments or reasons, as the starting point of that judgments or reasons, the information perhaps for the most important person in the case first. This is an area that the Nuffield Family Justice Observatory is currently doing some work on, so I hope there'll be more resources to support practitioners soon. But in the meantime, I thought I would feed back on conversations I had with the Family Justice Young People's Board a couple of weeks ago when I was discussing with them this issue. The young people that I met with, many of whom had been involved in quite lengthy protracted proceedings, none of them had any experience of a judge or magistrate's writing to them at the end of their case. But they were really enthusiastic about the potential benefits of this approach. And when looking at the letter that's on the slide, the letter from Judge John, they were really positive about how personal it felt, how clear it was that that judge had really engaged with the circumstances for these children. They really liked the fact that the judge had provided the children with something that they would be able to look back on in future years if they were unclear about what decisions had been made or why. They felt that using direct quotes was really helpful. They liked the language that was used. They said it was simple but not patronising. And most of all, they felt that this letter really demonstrated that the judge cared, that that's what they felt children needed to know when they were going through family courts, particularly when they had taken the time to feed in their wishes and feelings. As I said, this isn't a situation where it's a full judgment. It is a one-page letter, but I think it's really important to reflect on children and young people's responses to that and think about how adapting our practice so that this is something that happens more frequently might have real potential benefits for children in terms of their experiences of proceedings. Finally, then, 3 reflections on what I have been discussing today. And the first of which is about how we protect children. I think for a long time as a system, we have felt that not involving children, not talking to children about proceedings is the best way to protect them from any conflict that's happening between their parents. But I think the evidence base really challenges that. And if you think back to Jamie Craig's reflections, he talks about us not wanting to involve them because it comes from that protective standpoint, but understanding that children really don't necessarily experience that in the way that we intend it. That because they are actively, not passively, involved in their parents' separation, it's really important to give them the opportunities to understand what is going on and to feed in their views. The second point is to think about children's participation, not just about evidence, but about experience. That's going back to the jigsaw puzzle pieces that I was talking to about earlier. The first piece being about the importance of children's wishes and feelings as a part of the evidence jigsaw, if you like. But the other features that are really important, children having the opportunity to ask questions, children having the opportunity to understand who's making decisions about them, children really getting the benefits from feeling listened to, those are also just as important as the evidential benefits. And then finally, really understanding that there are practical steps that we can take every stage of proceedings to improve children's experiences. And that goes for all practitioners involved in the family court. As magistrates and legal advisors, you have unique opportunities within the case to reflect on the information that's being provided to you about what the child is saying, about how they want to be involved. You can ask questions about the options for participation that were discussed with the child. And by making yourselves available to meet with children, to write to children, to facilitate the types of participation that individual children in individual cases have told us they would like, you can really make a difference to those children's experiences of those proceedings and ultimately to their welfare. So that's it from me. The QR code that you can use there would take you through to a link to sign up to the Nuffield Family Justice Observatory's bulletins, and through those we will share any of our new research or events and also any resources that are being developed around this area that you might find useful in the future. Thank you very much for having me speak to you today, and I really look forward to finding out more about how the Wales Pathfinder areas are getting on in the coming weeks and months.